And of course, let me share the screen. Just one second. So this is what it is, part two of Kathleen's presentation. We have part two, of course. One is, of course, lying on the channel. So the mediation legislation symposium, how, what, when, where, which, who, why of it. Not going to take any time for this. And of course, the other part of it, which is the fact of where to get information and what's coming up, will always be available on mediatorvikram.com. So I don't need to get into that. So Parvati, it's all yours. Let's go straight into the topic, please.
Okay, thank you very much, Vikram. Now, before starting dealing with the topics, the specific issues I would like to speak about, if you allow, I would like to say some memories of mine regarding my character and my willingness to be a peacemaker since ever. I will start by saying that since when I was a child, before 100 years, I remember my father, who was a lawyer, and his father also was a lawyer. I remember my father saying, the worst compromise is better than the best trial. So I registered this in my mind. And when I became a lawyer, at the beginning, when I started, I used, before filing any lawsuit with any court, to send a letter, a comminatory letter to the debtor, when the debt was financial, when the issue was a financial debt, inviting the debtor to settle the matter within X number of days. Okay, some reacted positively, some ignored my letter, but once, and I was very surprised, this is why I remember this, a very, very nice colleague, very polite and very correct, called me when his client received the letter and said, my dear colleague, why do you feel the need to write? Don't you trust me? I was ashamed at that moment. I said, look, it has nothing to do with you. I trust you or I do not trust you, you trust me or not. This is not important for the dispute. We have to see where we go and where we end. And possibly the clients, both clients, change lawyers. Something in writing must be in the file. So after that, we became again friends. This is what I wanted to mention regarding my memories, and I will not say other.
But Parvati, I think what you're saying is important. I think if the lawyers themselves take that onto themselves, that let us first attempt. I think all this concept of mandatory mediation and all that's being spoken about, we won't even have to get into that. The lawyers themselves will try and do it, but to get to that stage, I think there's lots that has to happen in terms of the way lawyers look at their role. I mean, it's a noble profession, and that's the way we always talk about it. I think the role of lawyers is, I think, to be looked at.
The role of lawyers is extremely important, as you say, very pertinently. And I must say that according to my observations, the main resistance comes from the lawyer. Yeah. Because even if the client wants to solve a dispute amicably, and the lawyer says, oh, come on now, let's go to court, you will win more, or arguments like this. Although Article 3 of the new Greek law provides expressly, as the Code of Lawyers do, that a lawyer has the obligation, definitely, and if he infringes this obligation, he commits an infringement to the Code of Ethics. He must inform the client about the possibility to solve the dispute out of court, amicably. in spite of that, the resistance is still there. In order to make smoother the situation, Greek legislation provides that the participation of the lawyers in mediation is mandatory. The parties cannot be present. There are some few exceptions, but the rule is that they must be accompanied by the lawyers. This to make the lawyers more
yeah, so basically that's yes.
and more keen to accept
Parvati, can I take 30 seconds? 30 seconds, because you've picked up a very important point. I had put on my website also, Mahatma Gandhi had written this, which is something that I feel that every lawyer should also read. He writes, my joy was boundless. I had learned the true practice of law. I had learned to find out the better side of human nature and enter men's hearts. I realized that the true function of a lawyer was to unite parties driven asunder. The lesson was so indelibly burnt into me that a large part of my time during the 20 years of my practice as a lawyer was occupied in bringing about private compromises of hundreds of cases. I lost nothing thereby, not even money, certainly not my soul. Imagine, he's writing this how long back?
Excellent, excellent, perfect. And I would like to stick on, it's not the most important, but I would like to stick about the fact that lawyers do not lose money because they go to mediation. This is what they believe, but it is not true, because I had myself cases which lasted for 10 years. So after X number of years, the client is not satisfied, the lawyer is not satisfied, the lawyer personally hesitate to claim for additional fees, the client do not want to pay additional fees, nobody is satisfied. In mediation, if it is successful, if it is not, we lost nothing, a few hours. But if it is successful, we can finish in one day. And if not in one day, and it is postponed, in 2 weeks, 3 weeks, 1 month. So, and the client who is satisfied will bring other clients.
Yes, absolutely.
And the other clients. So we have nothing to lose, even on the financial level. So let me tell you now what are the issues about which I would like to speak. First of all, I would like to mention the mandatory mediation. Everybody is concerned by mandatory mediation. And I heard yesterday our colleagues who spoke, they mentioned mandatory mediation. I would just like to mention that the European directive provides expressly that mandatory mediation under strict conditions, severe conditions, can be applied. Based on that, the European Court, in the case Alessini and the legal actions Menini, which were ruled jointly, decided that mandatory mediation is acceptable, is lawful, provided there are the 4 following conditions. 1, provided they do not prevent the citizens from going to court. 2nd, that they do not make more difficult the access to the court. 3, that they stop the time limitation of the exercise of procedural rights. And 4, that they do not end, as a matter of fact, it is the first point, which I am mentioning now, but anyhow, the rank is not so important. Provided also that they do not end to a mandatory decision. And we all know that mediation is a free and opt-in, opt-out process. the person who is not satisfied may leave after 5 minutes or 2 hours without having to justify why he leaves. So these conditions being fulfilled, mandatory mediation is acceptable. And I was very surprised when I first noticed that the European directive goes even further than the national laws, because the directive provides that mandatory mediation is acceptable also for a recourse to justice, legal proceedings, to be acceptable as such, while the national legislations, among which Greek legislation, provide that mandatory mediation is acceptable, provided some conditions are fulfilled. I will mention immediately after that. For the legal proceedings, the recourse to justice to be heard, which is lighter. Initially, mandatory mediation has been introduced in Greece in 2018 by the second law, as a matter of fact, by a law of 2018, various articles of which, I mentioned them yesterday, have ruled mediation. This law provided that some cases, before being heard, the parties should go to mediation, and if it failed, they could proceed to the court. Otherwise, their recourse to the court was rejected. This was considered because, believe me, the bar associations of Greece find reached a common decision for once, and to file a recourse with the Supreme Court complaining about this law and saying that it was contrary to the EU legislation, which was not true, and that it refrained the citizen from going to the courts. The Supreme Court accepted this position, and if you read it, you will see that the point where it sticked was the fact that this preliminary mediation increased the cost, which prevented some litigants to have recourse to the tribunals. And thus, the mandatory mediation stopped. But thankfully, next year, the new law came, and it provided, but it went to the opposite extreme, which is that before going for a recourse to be heard before the court, I will mention which legal recourses apply, to which recourses this apply. The litigants must hold a preliminary first meeting of mediation, which is informative. To my opinion, this does not make sense, because the parties have been advised, hopefully, by their lawyers, by application of his obligation I mentioned before. Second, the mediator, before starting the process as such, is authorized to contact the parties, to have meetings with them, and to explain what is mediation and what they have to expect from mediation, mentioning the advantages and also the disadvantages of mediation, because there are disadvantages. Nothing in this world has only advantages. So this was smoother, and it was accepted, all the more that many cases are submitted to this initial meeting, mandatory meeting of mediation, which was copied on the model of Italian law. But Italian law does not provide that this first meeting is a meeting for information. On the contrary, this is provided by Greek legislation, with as a result that everybody considers that this preliminary meeting worth nothing. And we just lose time. In order to avoid this to be considered contrary to the Constitution, once again, the law has provided a very low cost for it, which is 50 euros for the entire preliminary meeting, regardless whether it lasts 1 hour, 2, 3, 4, 5 hours, which is excluded. Usually it's 5 to 10 minutes. But anyhow, it is 50 euros for both parties. The parties having instigated this preliminary meeting based on the relevant dispositions of the law pays the entire amount, and the other party has to pay half. If the other party does not, then the court, by its judgment, makes mandatory the payment of this amount as a judicial expense. Just to complete the information, I would like to mention the cases where this preliminary meeting is mandatory. It is the cases of family law, with the exception of divorce, of adoption, of contestation of adoption, of annulment of adoption, and annulment of marriage. All the matters for which the persons have not the right to dispose freely. Besides that, the mandatory first meeting of mediation must be held in cases where the dispute is, for the dispute, the district court is competent, provided the object of the dispute is equal or exceeds 30,000 euros. And all the disputes for which the citizens are entitled to dispose of their object freely, which are of the competency of the multi-member court of first instance. This makes a lot of disputes. Normally, this mandatory preliminary meeting should lead, as the law provides, to full mediation with the same or another mediator, as the law says. But unfortunately, the percentages of the cases ending to full mediation after this first mandatory meeting is not satisfactory at present. Our Turkish colleague yesterday mentioned figures and percentages. I cannot do so because only the Central Commission of Mediation of the Ministry of Justice has them. I have them, but I cannot disclose. This is the first bullet point I wanted to speak about. Another point, which is very quick, and I take the opportunity to speak about this. The mediator is liable only for willful acts or omissions, not for acts due to negligence. Now, there are three other points, but I do not think that I will have the time to expose them unless I go very quickly. One, which is very important, is the mediation clause. although Greek law provides that mediation can be agreed for future disputes, as a matter of fact, this disposition becomes useless because in another article, providing the cases where mediation is acceptable, the law says that the parties have to agree upon to go to mediation after the dispute has arisen. When it is a future dispute, first, we do not know whether there will be disputes. Second, definitely we do not know which disputes, if any, so they cannot be described. At the end of the day, we have said the interpretation was that in case of a mediation clause, the parties have to repeat the agreement which is contained in this mediation clause, which as a matter of fact is an agreement in the agreement. Okay, and if the party, one of the parties do not want to repeat, the clause is useless because unfortunately, there is no mediation plea as it is the case for arbitration. If you have an arbitration clause in a contract and one of the parties disregards this clause and goes to the court, if the other party raises the matter, the objection, the court has to send the matter to arbitration. But we have not such a disposition in our legislation, national legislation. In the other states of the European Union, it was definitely accepted because in Greece also there are courts which accept, and professors accepting that the mediation clause is imperative upon the parties. If there is a mediation clause, they have to follow this clause. Otherwise, the case cannot be ruled. There is a big percentage of the community of mediation, let's say, accepting this. In other states of the European Union, especially in France, the Supreme Court, where the Supreme Court of Paris has accepted that if there is a clause, the court must send the case to mediation and postpone the hearing of the matter before it. The postponement is a solution for all the litigants, all the parties. However, it could be very dangerous, not only regarding mediation clause, but in general. Because the law states that in case of mediation, if the court is aware of that, he must postpone the case for at least 3 months, but no more than 6 months. This is a very correct approach of the law, because otherwise, if we left without any, without mentioning any time limit, this could be very dangerous. And the party who would like to take advantage out of that would be able to do so. So in all the cases where there is a mediation, the court postpones for 3 to 6 months.
But Parvati, if there's an urgent relief required, in that case, how is it dealt with? Supposing there's an urgent relief required by one of the parties.
Can you repeat, please, Vikram?
Some urgency in the matter, some urgent relief is required. In that case, how is it provided for?
These are the measures which have to be taken in some cases where there is an emergency. The law provides expressly that regardless to whether there is mediation or not, such measures can be taken immediately. without postponement and without waiting.
Because what happened in India was that we have a Commercial Courts Act that any suit, a case that you want to file, a commercial matter, you have to send out a notice to the other side, and then after that they can reject it, but you can't file it. But if there is some urgent relief required, then you can file it. So everyone says some urgency is there, and everyone bypasses that requirement. But
Vikram, the courts are so overloaded that even for emergency measures, I'm not sure at all that the courts respond to the emergency.
Emergency is not taken as an emergency. But we are saying hi to Alice, but after this session, we'll get you in. Yeah.
Good morning.
Morning.
Or good afternoon.
Good evening.
Hello.
Good afternoon for Parvati. Good evening for me. That's how we were just discussing that. But we'll discuss it after. She's short of time, so we have to go through her thing as quickly as we can. Yes, Parvati.
Shall I continue?
Yeah, please.
I thought. So, 2 words about the enforcement of the agreements resulting from a mediation. The European directive provides that any of the parties can claim for such an agreement to be declared enforceable by a court or another authority, provided at least the other party does not oppose to that. On the contrary, Greek law provides that any of the parties, regardless to which attitude is adopted by the opponent, can go to the court, submit an original copy, meaning signed in original, to the secretary of the court, who hands this copy to the president of the court, who affixes the enforcement formula. You pay, I do not know, a small amount. I think it's again 50 euros. And you can proceed in the same way as if you had in hands an enforceable judgment of the court. At this point, I would like to underline that one could ask whether this disposition of Greek legislation is in accordance with European law, because the directive provides for a court judgment or a decision of another competent authority, while Greek legislation provides that you go with the agreement, you submit it to the clerk of the court, the formula of enforcement is affixed by the president, who does not validate the agreement. He just checked that this agreement is actually an agreement having accrued out of mediation, and that's it. Is this compatible with the European directive? The answer would be no, if the directive itself did not provide that its dispositions regarding the enforcement of the agreements resulting from a mediation do not affect the national legislation of each concerned state. That's it. I have another point, but I will stop because I will exceed very much.
Quickly, you just put out the point. Put out the point. We can then maybe discuss it later. At least put it out. It's good. Maybe we can do that in the workshop after we start that series. We can.
Okay, with pleasure. It is important. It is this point concerns transborder disputes, which are considered transborder disputes according to the EU legislation, which one according to Greek legislation, and what happens to these disputes. I will just add now that Greek legislation has extended the application of the law which was put into force in compliance with the EU directive also to domestic disputes. So it is important to clarify whether it is a transborder one or not. This is for the moment. Save the rest during the workshop.
Yeah.
Thank you very much for inviting me.
Well, thank you very much. Look, the idea of the symposium was let's at least get these points out and we'll keep on discussing them. And of course, workshop, we'll discuss more about it. So thank you very much. And let me start that live stream. My studio